This week in Canadian news, Redux has reported on an Alberta mother and her 14-year-old daughter who were faced with a man in their change room who was, quote, naked except for fetish gear. The woman, who is being called Carrie, and her daughter had a lovely day planned at their local pool, but when they entered the ladies' change rooms, there was a man lurking wearing an exposed breast form and a black penis sling. Carrie immediately ushered her daughter out of the change room and reported the incident to pool staff, who chastised her and told her that they had an inclusive policy that allowed everyone to use whichever change room they felt most comfortable in. As usual, it seems this does not apply to women and girls. Carrie called the police and was approached by a female staff member while she was waiting for them to arrive. She recorded the conversation and provided it to Redux. She can be heard saying, quote, "I am telling you right now, he is a balding man in his 40s wearing a penis sling and rubber breasts around his neck. Fetish rubber breasts slung around his neck. He is in the women's washroom. I walked in with my 14-year-old daughter. I am 54. I should not have to put up with it, but she should definitely not be exposed to a man enjoying his fetish in the women's washroom." The female staff member reiterated the policy of allowing poolgoers to use whichever change room they choose, and then defended his fetish gear, stating that, quote, "they can wear whatever they are comfortable wearing." The Edmonton police were equally as dismissive. When Carrie pressed the constable on whether a 14-year-old girl should be faced with a middle-aged balding man in fetish gear in her change room, the constable stated that the police service takes no position on the matter. The police report used gender-neutral pronouns for the man and stated, quote, "the person's penis was covered by the penis sling. However, the fake breasts were bare." Redux learned that this man frequents the Booney Dune Leisure Center pool. Carrie pointed out that there is a school next door to the center and that young girls use this change room regularly. In other news, a man has pled guilty in an Edmonton courtroom to trafficking a 13-year-old BC girl. 29-year-old Cameron Alexander has admitted to trafficking someone under 18 and to obstruction of justice. The girl was just 12 years old when Alexander met her in 2022. Alexander's phone was seized in 2023 and revealed that he'd been directing the girl for months regarding providing sexual services in exchange for money. While in custody in Edmonton, court documents indicate that Alexander continued to contact the victim despite there being a no-contact order. The documents also state that he urged her to plead his innocence and also, quote, "gave her tips on how to best advertise her services and encouraged her to recruit other women to become sex workers and then send him the money earned by them." The document also stated that during the offense period, Alexander, quote, "influenced, directed, and exercised control over the victim in engaging and continuing to engage in prostitution." Alexander is back in court for a sentencing hearing later this week. And finally, a trans rights activist who goes by Marnie Panas has filed a complaint with the Alberta Human Rights Tribunal because he claims he was discriminated against when he called for a wellness check for a friend in 2019. According to Panas, he was misgendered by dispatchers over the phone. The tribunal found there was discrimination but dismissed the complaint, saying dispatchers didn't mean to misgender Panas. And so Panas let it go and moved on. Just kidding. Of course he didn't. Panas has appealed the decision, stating, quote, "this isn't about my hurt feelings. I'm fine. It's about the systemic issues that impede people's participation in the police service from communities like mine and the significant trauma that I experienced when I called asking for help and was further harmed by the very people who should be there to protect me." During the hearing, one of the operators said that he later received training about asking callers how they wish to be addressed and that he did not mean to disrespect the complainant. Panas says that training and policy updates are not enough, stating, quote, "to build trust with the community, they have to be held accountable. For somebody like myself thinking, will I phone 911 again in the future if I find myself in a similar position? The answer is probably no. And that is a very real experience for most people in our community." Just to be clear, the incident that he's carrying on about involved him being called sir and buddy by dispatchers, who clearly heard a man's voice over the phone because he's a man. And that's all I have for you from Canada today. Take care.
I'll begin by mentioning the latest items our chapter has been working on. Last week, we published statements by our Lesbian Caucus and Lesbian Bill of Rights International that were sent to the CEDAW committee in response to its requests for submissions on the subject of gender stereotypes and how to combat them. We also published an interview that Elizabeth Chesick, coordinator of our Desisted and Detransitioned Women's Caucus, did with detransitioner Claire Abernathy. We've also been busy planning for two upcoming events. On March 8th, International Women's Day, we'll be holding simultaneous protests across the US to bring attention to the obliteration of Afghan women's rights under Taliban rule. 3 locations are involved so far, and we hope that more will join us. Women interested in participating or hosting an event in their city are encouraged to reach out to info@womensdeclaration-usa.com for more information. We also announced that our next month's webinar, scheduled for the 22nd of March, will focus on amplifying the voices of the voices of the women of Afghanistan, and will include testimonies collected by WDI Afghanistan country contact Yao Bano and read by WDI USA volunteers. Moving on to state-specific news, this past Tuesday, Republican legislators in Kansas voted to override Democrat Governor Laura Kelly's veto of SB 63, the Help Not Harm Act, which prohibits the medicalization of minors. The bill also creates a civil cause of action exposing a gender clinician to liability for any harm up to 10 years from the date of the patient's 18th birthday. On Wednesday, the Wisconsin Interscholastic Athletic Association updated its policy on student eligibility in sports. Unfortunately, it was inspired by and uses similar language as the recently updated NCAA policy, which means it does not comprehensively protect female athletes. Also from Wisconsin, Governor Evers' attempt to recognize same-sex marriage by making references to spouses in state statutes gender neutral in this year's executive budget bill has resulted in a document that strikes the word mother and replaces it with inseminated person in the section addressing artificial insemination. Thanks to Lauren and the SLA team, I was able to send written testimony opposing bill to the Joint Committee on Finance under the WDI USA letterhead. On February 18th, the Department of Education's Office of Civil Rights announced the launch of a Title IX violation investigations into the Maine Department of Education, as well as Maine School District number 51, after it was reported that Greeley High School is continuing to allow at least one male student to compete in girls' categories. That student would be male athlete Katie Spencer, who last week won a state girls title in pole vaulting, defeating the closest competitor by more than 6 inches. Outkick also reports that last year, while competing against other boys in the state meet, the best John could do was tie for 9th place. Kara dedicated her weekly Female Free Speech Friday Substack post to 15-year-old female athlete Frances Stout, a JV basketball player for the Tumwater School District in Washington State. Earlier this month, during a pregame warm-up session, Frances noticed that the opposing team included a male player and immediately brought her concerns to school officials, asking that they either remove him or stop the game entirely. They refused, citing the WIAA policy against gender identity-based discrimination, to which she replied that it is actually the failure to remove a male from a basketball game meant for girls that constitutes discrimination, and opted to remove herself from the game for her own safety. On the 17th, with the backing of the organization Foundation Against Intolerance and Racism, Francis filed a federal civil rights complaint against the district with the Office of Civil Rights, alleging sex-based discrimination in violation of Title IX. Next, I'll give an update on the status of 3 lawsuits challenging Sections 4A and 4C of Trump's Defending Women EO that address getting men out of women's prisons and ensuring that no federal funds are used for gender-affirming treatments. A January 6 ruling in Moe versus Trump, granting a temporary restraining order blocking implementation for the male plaintiff only, remains in effect. With regard to Doe versus McHenry, Keep Prison Single Sex USA reported that on February 18th, the court issued a now in effect preliminary injunction that only blocks implementation with regards to its 3 Jane Doe plaintiffs, which means that for now, these 3 male inmates will remain in a federal women's prison and have access to estrogen, etc. What isn't clear is if this also means that the transfer of male BOP inmates who are not plaintiffs will continue as the EO directs. That appears to be the case, as on the 20th, male inmates were allegedly removed from general population into segregated housing and informed of their imminent transfer to male prisons, prompting the filing of an amended complaint, which adds another 9 male plaintiffs to the original 3 seeking to halt their transfers. A third suit, Jones versus Trump, was filed on February 10th by a male BOP inmate against the EO on similar grounds as the other 2 cases, with an emergency motion for a TRO and preliminary injunction filed on the 21st. Also on the 21st, the Bureau of Prison issued new guidelines for the treatment of trans-identified inmates, which according to the New York Times included banning the use of preferred pronouns, stopping special pat-down procedures, and rejecting underwear requests. Another suit against the Defending Women EO, this one pertaining to its Section 3D requiring that passports and other government-issued ID documents accurately reflect an individual's sex, was filed on February 7th. In Orr versus Trump, the ACLU and Big Law co-counsel Covington and Burling argue on behalf of their 7 trans or non-binary clients and others similarly situated that the policy is arbitrary and capricious, violates the right to travel and right to privacy under the Constitution's due process clause, violates its equal protection clause, and compels speech in violation of the First Amendment. The suit includes a motion to stay agency action and for preliminary injunction, which to my knowledge has not yet been ruled on. That's all I have today. Thank you.
In New Zealand, there were several further responses to the report of the IPCA, which is the Independent Police Conduct Authority, about the police response to the Let Women Speak rally in March 2023 in Albert Park in Auckland, which was part of it, which they placed submerged inside of a broader document called Policing Public Protests in New Zealand. Now, Speak Up for Women welcomed the IPCA report because the report was very critical of the police actions. Speak Up for Women appeared to accept the IPCA's view that part of the problem was police uncertainty about their powers and that a solution could be to give the police more powers. Of course, the problem being that police didn't do anything to protect the women when they were subjected to violence from 2,000 rainbow people. That's about 200 peaceful older women, and Kelly J. Keane. Other organisations were very critical of this proposal to give police more powers, including the Free Speech Union, the Civil Liberties Union, WDI New Zealand, and the Women's Rights Party. It's true that the IPCA report has acknowledged that the police response to the violence at Albert Park was inadequate on all counts, from inadequate risk assessment through to failure to respond to unfolding events and failure to prioritise public safety. One of the worst things in the report, though, is the lie that the police escorted Kelly J. Keane through the crowd out of the park. They did not. She was helped out by courageous women marshals and a couple of security guards. The police only helped once she was already out. After the report had vindicated that the women were treated appallingly by the violence of the trans activist mob and by the deliberate choice of the police to do nothing to help them, then the IPCA goes on to recommend giving more power to the police, which doesn't seem logical. It's also of note that the report about Albert Park was buried in a larger, more general report so that the harm that was done to women and the police inaction still has not received the public attention and vindication that it deserves. The Women's Rights Party, in their media article, and I'll post some links up hopefully shortly, and some of this has also gone onto the WDI website. Their article was entitled, "Giving Police More Powers to Constrain Protest is Not a Solution to Police Failings." They said, where is the apology to the women and men who were in Albert Park, who are still traumatised by their experience, and to those from the wider New Zealand community who continue to suffer from the chilling effect of knowing that they cannot rely on the police to protect them? Hang on. I've just lost my place here. Now, the WDI NZ New Zealand noted that the IPCA failed to mention a possible bias within the police against Let Women Speak event, reflecting the bias in the wider society, which reached a fever pitch in the mass media during the week before the event. And the IPCA also didn't look at the influence of the police diversity unit on the police attitude or actions. On Saturday, 22nd of February, Jill Ovens from the Women's Rights Party spoke about the IPCA report at the WDI Australia and New Zealand Feminist Question Time webinar. So now there's also been more about Destiny Church, which I reported last week had gone into the Te Atatu Library in Auckland, frightening the women and children, where they tried to stop a drag queen story time event. They're a sort of very conservative Christian church who are pretty anti-gay and anti-transgender. Now, Resist Gender Education published an article entitled "Losing the Plot at the Library, Drag Shows Are Not for Kids." And they were saying that the underlying reason for the Destiny Church protests at the library has become obscured. And that Brian Tamaki, who's the leader, it talks about the need to protect children, but it's protection from gender identity ideology that is necessary. And they explain why gender identity ideology is such a problem, saying at first glance it might seem harmless to let children identify as the opposite or neither sex when it's part of childhood imaginative play. But when adults start affirming a child's imaginary sex as a reality, a cascade of significant consequences is set in motion, and they talk about how it can lead to children taking puberty blockers and having a lifetime of medicalisation, and also being exposed to adult sexuality in these library events, and how none of this has got anything to do with gay rights. Now, there's been a lot on Twitter about Destiny Church and more responses as well. But Brian Tamaki certainly is revealing himself to be very anti-gay. He's put on Twitter a poster saying, "Let's make New Zealand straight again and keep New Zealand pure." And also there's a big response supposedly to Destiny was that the trans activists, the rainbow community, held another rally in Albert Park, which is hardly just a coincidence that this rally is happening just after the IPCA report about what happened at Albert Park, and it's very close to the 2-year anniversary of that. So their rally, they put publicity out saying, defying destiny, day of queer power, these queers bash back. And the very violent phallic imagery in their poster. So by holding this event at Albert Park, it seems that they are falsely conflating the peaceful Let Women Speak event at Albert Park with the aggressive Destiny males' actions, and also that by calling for a kind of challenging Destiny to a fight, it appears they're not sorry for mobbing and bashing the women and would do it again. They're still keen to engage in these aggressive actions. So on Sunday, the rainbow event at Albert Park went ahead peacefully because Destiny did not turn up. By holding this event on this anniversary of when the violence against women happened from the rainbow community, this reverses history, in my view, and paints the rainbow people and their supporters, which is the trans activists really, as the peaceful victims reclaiming themselves rather than the violent aggressors that they were. So it's a kind of rewriting history, and it got a sort of benevolent reportage in the national news. They're demanding that Destiny Church loses its charitable status and all government grants, and demanding full funding of medicalised gender treatments. So lastly, an item appeared on New Zealand Doctor, which was reported on Twitter, X. They are apparently, doctors are receiving letters warning of legal action if they do any kind of gender affirming care. So it seems the ones who are practicing gender affirming care are receiving these letters. And the letters contain a fair warning of the potential for legal problems in the future. So that's my report. Thank you.